Can law enforcement legally track your location using historic cell phone records, cell site records? The United States Supreme Court case of Carpenter answers this question. In the Carpenter case, the FBI obtained approximately 12,898 different location points that recorded the defendant's location over a period of approximately 127 days. The FBI secured the data from wireless carriers without first securing a warrant based upon probable cause. The Supreme Court sought to answer the question whether a warrant was required to get that data. So, wireless carriers, like many companies, collect data from their customers, and wireless carriers collect data associated with their customers' usage of their services. When you use a cell phone, generally, the cellular signal connects to antennas known as cell sites. The companies store this data for a variety of legitimate business purposes, and as a result, the records are able to record information pertaining to the location of a particular cell phone at specific times. In the Carpenter case, the FBI was able to secure phone numbers of robbery suspects, and the investigators and prosecutors thereafter secured a court order pursuant to the Stored Communications Act. This order required the wireless carriers to produce the requested cell site records. However, the standard that's employed to obtain an order under the Stored Communications Act is much lower than the probable cause standard that is required to obtain a valid search warrant. Specifically, the Act required the government to simply show that reasonable grounds for believing the records were relevant and material to an ongoing investigation. So, that's a very low standard. All the government had to do was go into court and simply show that there's reasonable grounds for believing the records were relevant and material to an ongoing investigation. That's not the same as the probable cause standard required in order to secure a search warrant. As a result, the defendant in Carpenter filed a motion to suppress the evidence associated with the cell site location data. The motion argued essentially that the Fourth Amendment right to be free from unreasonable searches and seizures was violated when the government seized the records without first securing a search warrant supported by probable cause. Now, the trial court denied the motion to suppress, and Carpenter was convicted. The appeal was first presented to the Sixth Circuit Court of Appeals, and the appellate court upheld the conviction and affirmed the decision of the trial court. However, the case was ultimately appealed to the Supreme Court of the United States, and in June of 2018, the Supreme Court overturned the decision and held that the provision under the Stored Communication Act falls well short of the probable cause standard that's required for the issuance of a search warrant. As such, the Act is not a permissible mechanism for the government to utilize in order to secure historical cell site records. The Fourth Amendment, within the syllabus to its opinion, the court noted that the Fourth Amendment protects not only property interests, but certain expectations of privacy as well. So when an individual seeks to preserve something as private, and the expectation of privacy is one that society is prepared to recognize as reasonable, then official intrusion into that sphere generally qualifies as a search and generally requires a warrant supported by probable cause. The court also explored the third-party doctrine. This was prompted because the government argued that the third-party doctrine was applicable in Carpenter because the cell site records were voluntarily provided to the wireless carriers by the user through the use of their networks. As such, the government contended, the records were business records, and since they were shared by the user, there's much less reasonable expectation of privacy in the information since it was already shared with a third party, specifically the wireless carrier. So the government essentially was arguing here that the wireless carrier company had the information because the customer, the suspect in this case, voluntarily shared the information with the wireless carrier. So what reasonable expectation of privacy does anybody have in information that they provide to a third party? This also reminds me of what we often call the false friend doctrine. If you tell a friend something, okay, and it turns out that they're a false friend, if they're a confidential informant, or they're somebody that's aligned against you, and they pass that information on to somebody else, you have no reasonable expectation of privacy in that information. When you provide or share information with others, you often run the risk that that information, whether it's data, whether it's simply statements, could be shared with law enforcement. However, in this case at least, the Supreme Court rejected these arguments and found that the cell site location records were of such a nature that there was a world of difference between the type of personal information collected by way of the cell site location records and the information collected in other cases. The detailed and revealing contents of the cell site location records are such that mechanical application of the third-party doctrine would be improper. So the court really dove in and looked at the detailed, exhaustive nature of these records. I mean, we're talking about an encyclopedia level of information with respect to location. And as technology improves, we can only imagine that this location type data is going to get more precise. The other thing the court looked at was the pervasive nature of technology, specifically cell phone technology. And there's so much data and important data that people store within their phone, sometimes without them even knowing. I mean, I'm certain that there's people who use their phone that don't realize that they're being tracked in such a way that over a 6-month period, the company knows 13,000 different location points associated as to where they are, and those records are kept. A lot of people might not know that, and I think that's just the tip of the iceberg when it comes to using different applications, different software. Where does your data get stored? What third-party companies does it go through? Nobody reads the various agreements when they click to accept the terms of service, it seems, to download an app, and those terms of service are always changing. So how many third, fourth, fifth, sixth parties are out there that have access to your data? And some of that data might be very intimate. It's related to your business, it's related to your finances, it's related to your family, it's related to your political beliefs, your religious beliefs, the things that people hold most sacred. So when it comes to privacy and the expectation of privacy. So what are the implications of the Carpenter decision? Well, the court noted that the decision in Carpenter is a narrow one. There's no doubt about that. It doesn't call into question other more traditional surveillance methods that are utilized by the government or the appropriate application of prior precedent associated with the third-party doctrine. However, it's apparent the court has not disregarded the Fourth Amendment implications that are associated with all of these advances in technology. These advances often provide such great benefit while simultaneously revealing intricate, exhaustive, personal details to third-party companies. Again, is Google your friend or are they a false friend? What do they do with the data they collect? What does Facebook do with your data? Where is your data? When you upload something, when you like something, when you save something, when you share something, where is it going? Where does it stop? Who has access to it? What are their requirements? Can law enforcement simply go in and look at these records? Well, I guess it depends. But certainly the Carpenter decision adds a layer of protection to require government to show probable cause rather than the lower standard under the Stored Communications Act. So going forward, expect defense attorneys to raise arguments where appropriate that incorporate the Carpenter decision going forward in any case that involves cell site location records that were obtained without a search warrant supported by probable cause, but also in other cases where the government secures data and records from third parties and where the defendant has a real claim of a legitimate expectation of privacy analogous to the circumstances in Carpenter. I just expect this issue to continue to evolve as we go forward with all of the changes in technology. The traditional false friend third-party doctrine, it can be undercut, I think, by the reliability and the arguments associated with respect to the type of data that's involved, the detailed nature of the data that's involved, and nearly everybody's reliance upon the technology in daily life. Whether you're working, socializing, whatever it may be, most people utilize some form of internet-based communication, whether it's through a smartphone or through a laptop, and the amount of data that is collected and the detail associated with that data is unbelievable. I mean, the idea of tracking somebody and getting 13,000 different location points over a period of 6 months, that's not something that could have been easily accomplished prior to the advent of the internet and these cell site locations. That would have been almost impossible. Imagine, at the time the Fourth Amendment was put into effect in the 1700s, the idea that somebody could track a person's location with such detail over a period of 6 months and have 13,000 different location points, it simply doesn't even seem possible. But now, by operation of this technology, that detailed data is collected so easily, so inexpensively, and just as a matter of course. Really, I mean, it's not even really that much up to the control of the user. You turn your cell phone off and it's connecting to various cell towers. So the implications here, I think, are great, and these issues are going to continue to arise with the changes to technology. And I think the court is looking not just at the Carpenter case in detail, but also in future cases how this can be applied and how it may need to be applied. So if you have a question regarding the Fourth Amendment, motions to suppress, or if you are in need of a criminal defense lawyer, we invite you to contact the Frey Law Firm today for a consultation to learn more about the Frey Law Firm's commitment to defending those charged with crimes involving computers, the internet, data storage devices such as cell phones. Please visit our website at internetcrime.com for much more information. We invite you to contact us, and we look forward to speaking with you.